case of a buyer wanting to move in early, we generally have to be concerned about whether or not, depending on which side you represent. If you represent the listing side, my recommendation to my seller is always no. If you represent the selling side, your buyer is your customer. You are supposed to serve your customer. And if he has a need to move in earlier, you are supposed to help him. But you are also supposed to tell him what are the risks involved in moving earlier. What are the risks to the seller and what are the risks to the buyer? The risk to the buyer generally has to do with what if you don't close escrow? You know, and then you got all this furniture that is in the house. You have to move again. But generally, when a buyer asks to move in sooner, that buyer might have a lease that just expired, and he doesn't want to extend his lease because he just bought a house. So instead of temporarily moving his furniture to a storage, he would prefer to move the furniture into the house that he just bought. Because if he signs a temporary storage lease, he has to put deposit, and it doesn't make any sense to the buyer, right? To sign a self-storage for just a couple of weeks. So I think usually it occurs when the buyer has to move out of some place and really have no place to go. I think it has to do with planning issue for this particular buyer. Maybe he didn't plan as well, but you are his agent, though. You're supposed to help him. Now, when you have a request like that, you're supposed to approach the listing agent and ask if the seller would agree, right? Chances are most sellers would say no. Okay, if the seller say yes, great. Then you are going to need to review this form, which we are going to look at. And that is the Interim Occupancy Agreement. Let's look at this form. Interim Occupancy Agreement, buyer in possession prior to close of escrow. This is where you put the seller's name, and then below it is where you put the buyer's name. And then there's a place for you to put close of escrow is scheduled to occur on whatever date. So there is a scheduled close of escrow date. So this is where you put the scheduled close of escrow date. And then the actually usually the buyer and seller's names are automatically populated. But since I don't have an existing folder for this, it's blank. And then the property address is usually just auto-populated, so you don't even have to type it in. And on 1B, the premises are for the sole use as a personal residence by the following named persons only. Usually, it's just the name of the buyers. Term, the term begins on. That is the first day that your buyer wants to move in his furniture. The first day that your buyer wants to take possession of the property. So you put the date here. And shall terminate at, you specify the time, on the earliest of the date scheduled for close of escrow of the purchase agreement as specified above, or as modified in writing, or mutual cancellation of the purchase agreement. So this particular form contemplates that there is a possibility, such as in the case where the buyer could not get the loan approved and the buyer has to cancel the purchase agreement. So this particular agreement actually contemplates a situation where the buyer has moved in and then may have to cancel the purchase agreement. Hopefully everything goes well and he didn't have to cancel, okay? But it's the earlier of the two. So if the buyer can't close in time and because he wasn't able to get a loan, he has to cancel this interim occupancy agreement. And then it also says tenant. Interestingly, the word tenant is used and the word landlord is used. So this one contemplates a tenancy relationship, your regular tenancy relationship. So it says tenant shall vacate the premises. So the buyer is not only a buyer. By signing this interim occupancy agreement, the buyer actually became a tenant to the landlord, even before escrow closes. Because until escrow actually closes, who is this person that is on your property? This person is not an owner yet. It's just a buyer / tenant. That's what this is about. It says the tenant shall vacate the premises upon termination of this agreement unless landlord and tenant have signed a new agreement mandated by local rent control law, or the landlord accepts rent from tenant, in which case a month-to-month tenancy shall be created, which either party may terminate pursuant to California Code, Civil Code 1946.1. So this one basically says the tenant shall vacate the premises when the agreement is terminated, unless the landlord wants to keep this buyer as a tenant, even if the buyer can't close escrow, which I think is pretty rare. Okay, most of the time when the agreement terminates, the landlord wants the seller wants the buyer out. And then on an interim occupancy agreement, you're supposed to specify how much the rent is. Typically, the market rent divided by, well, whatever the market monthly rent is. So you put it right here on 3A.
So is it not by days? Say if you want to...
You can actually decide, okay, you can actually prorate this thing. But for example, if the guy is just going to be expected to only stay for 10 days, you have to kind of modify this thing here. Tenant agrees to pay whatever per month for the term of this agreement. So the agreement does not anticipate it's going to be less than a month, but if you put per month, and then you add something in the addendum that specifies how many days it's going to be there and just prorate it, that's fine too. So if it's $3,000 per month, it's just going to be there for 15 days. You will put something in the interim occupancy agreement that the buyer will actually be charged for the actual number of days that he has possession of the property. You can actually modify it. This one actually contemplates a longer period than 10 days because it actually asks for a security deposit. So, you know, now it's a good idea for the seller to collect a security deposit from the buyer. What if the buyer goes in and damages the seller's property, right? And then he couldn't close escrow. The seller needs to have some kind of security deposit, so that has to be specified here. Now, B would apply if it's longer than a month because it says rent is payable on the first day of each calendar week. First day of each calendar week. So this seems like it's anticipating a weekly type of thing. And it's delinquent on the next day or in full at close of escrow. Oh, so you have a choice of collecting the rent up front or collecting the rent at close of escrow. If you are the listing agent, which do you prefer? I want to collect the rent up front because, you know, if you wait and the guy can't close escrow and he's not paying you rent, and then you have to evict him, you're going to suffer more financial loss, right? Okay. But or you can specify any other terms here. Okay, you have that option. The rent shall be paid by personal check. This one, you can decide how you want the rent to be paid. Okay. That's very typical of a lease. We're not gonna spend time on it. Okay. And then and then 4 and 5 is actually pretty standard, like a standard residential lease. So we're not gonna spend time on it. Okay. Number 6 is like a standard lease. So is number 7 and number 8, number 9. 10 is like a standard lease. 11, same thing. 12 is almost like a standard lease. 13, 14, 15, they are like a standard lease. 16, like a standard lease. 17, 18, same thing. Okay? So we're not going to spend time on it. 19, 20, 21, same thing. Now, 22. Remember, this buyer is going to become a tenant if you allow buyer to move in sooner. So he's entitled to have that lab-based pain disclosure. But he's already a buyer anyway. Most likely he got one from you already, right? 23, 24, 25, those are all standard disclosure. Possession, this is your typical lease. Tenant's obligation upon vacating the premises, that's pretty standard as well. So everything is consistent with a standard lease. Let's look at number 30. Temporary relocation. Subject to local law. Tenant agrees upon demand of landlord to temporarily vacate premises for a reasonable period to allow for fumigation. I don't think this applies anyway in most cases, so I won't talk about it. Damage to premises is actually pretty standard. Insurance. Now, if you're the listing agent, you want to make sure that the buyer gets a renter's insurance, okay, to protect the buyer's own properties. That's pretty standard on the residential lease anyway. 33 is standard because you normally do not want your tenant to bring in water beds, okay, unless they have a waterbed insurance policy, okay. 34 is standard, 35 is standard, 36 standard, 37, that's pretty standard, 38 standard, 39 standard, 40 standard, 41. It's very typical of a residential lease, so I will not go over it. Agency confirmation, that's pretty standard. And then number 44 talks about interpreter, translator. Now, in case you are not familiar with this, in California, there is a law that says if the lease is negotiated in a language other than English, and it's one of these 5 languages, Mandarin, Vietnamese, Korean, Spanish, I can't remember what the 5th one was. Huh? Tagalog, 5, yeah, 5. If it's any of these 5, then you're supposed to provide a translation of that lease to the tenant, okay? So that has to be observed. Now, if, for example, this person speaks one of these 5 languages, however, the lease is negotiated through an interpreter, then you can go ahead and check 44, okay? And then you will say what language is being translated for, okay? Oh, I see where Selena was reading from. 45. Yeah. Okay. I see. All right, so that's very typical. So you're almost like signing a standard lease, even for a buyer interim occupancy agreement, right? There are only a few variations, but it's almost like a standard lease. Now, no, I noticed that this one does not have a place for you to write down how many days the guy is going to be there. Now, here, usually you have a term though. This is where you write down though, right? Commencement date, right? But then the ending date, there's no place for the ending date. It kind of depends on when the escrow closes or when the purchase agreement is canceled, whichever is earlier, right? But then here you got a problem here. It says agrees to pay how many dollars per month, and then it says rent is to be paid when. It really does not have an addendum where you basically say, well, rent will be prorated. So probably you need to add some kind of addendum, because if you have like $3,000 per month, right? Are we to assume that if the guy is only there for 15 days, that he only pays $1,500 a month? We really can't assume that, although you could, right? Okay. All right, so much for the buyer interim occupancy agreement. Now we're going to look at another situation, a slightly different situation. This time is the seller who wants to hold over after close of escrow, right? Okay, let's look at that one. Let's look at this one, seller in possession, okay? Seller license to remain in possession addendum. What does the word license really mean? It means that it is not intended for the seller to be a tenant, which is different from the buyer interim agreement, whereby it was intended for the buyer to be a tenant. So in a situation like this one here, where the seller have to remain in possession after close of escrow, this particular form does not convert the seller into a tenant. Why is it that you do not want the seller to be a tenant? The reason is, if the seller is a tenant, he has tenant's rights. Tenant has more rights than someone who is not a tenant. So you don't want to give the seller more rights than what he is entitled to under the law. They say that if you only use this form if the seller only remains in possession for less than 30 days after close of escrow. If the seller remains in possession for longer than 30 days, there is a different form. So do not use this form if the seller remains more than 30 days on the premises after close of escrow. So now let's look at the form. Is this something, this seller license to remain in possession? The word license means with the owner's permission. However, who's the owner after close of escrow? The buyer will become the owner, right? So the seller is just a person who would have the owner's permission to be there for a certain number of days after close of escrow. We do not want to convert the seller into a tenant, because there's all kinds of problems. There's more risk to the buyer to let the seller stay there for more than 30 days. There's another reason you do not want the seller to remain there more than 30 days. That reason has to do with loan. There are many loans, such as the FHA. FHA, they prohibit seller holdover for longer than 30 days. Keep that in mind. If you have FHA loan, many lenders, not just FHA though, I think many lenders they don't allow seller to remain in possession for longer than 30 days. Because if the seller remains in possession for longer than 30 days, it would mean that the buyer has failed to take possession within 30 days. There are many loan programs that requires the buyer to take possession no later than 30 days after close of escrow. You always want to keep that in mind, okay? So even if you were to agree to let the seller remain, try not to go beyond 30 days to prevent this type of problems from happening, right? However, if you have an all-cash buyer or you don't have any loan issue, then you may be able to go ahead and allow the seller to remain longer than on the property longer than 30 days after close of escrow, in which case you would use a separate form. We'll get to the separate form later, okay? All right, let's look at the form. Now, I was going to talk about when is a good time to use this form. If you are the listing agent, if you already realize your seller is going to have to remain. Now, say, for example, you have gotten like 20 offers. You're the listing agent. You have an all-cash buyer who said, I want to close escrow within 30 days. And he has the highest, his offer is the highest. So you don't want to lose this person, right? But then your seller has to find a replacement property. So your seller may have to remain in possession after close of escrow. Now, what if you have an all-cash buyer who just want to close escrow by a certain date? Maybe your all-cash buyer doesn't need to take possession right away, but is willing to allow your seller to remain in possession. If that's the case, certainly you want to negotiate upfront with the buyer to allow the seller to remain in possession after close of escrow, a certain number of days after close of escrow. That would be a good time to use this form. Oftentimes what I see is this form does not get used until after escrow has been opened. And then listing agent contacts the selling agent and asks the selling agent if he will present this form to the buyer and ask the buyer to agree to sign this form. Many buyers will say no. If the buyer says no, of course it creates a conflict. So you might want to keep that in mind to use this form early if you already realize there's a need to use this form, okay? You have the buyer and the seller's name, which will be automatically populated. And the term will be just for a number of days after close of escrow, preferably less than 30 days. In fact, if it's greater than 30 days, you use a different form. It may or may not be with consideration. It can be with zero consideration, or you can negotiate a rate for the license. It's called license fee. You don't call it rent because this guy is not a tenant. We do not want to make him a tenant. We make him a licensee, which means that he pays a license fee for whatever the consideration is. And it says seller shall deposit such funds with escrow holder prior to close of escrow, or such funds shall be withheld from seller's proceeds. There are two ways to do it. So if you're going to let the seller stay there for 29 days, and you decided it was going to be, let's say, $30 a day, so that will be about what? 870. 29 times 30 now.
39.
Huh?
30 is 900.
3,900?
30 is like $30 per day.
$900.
$900.
About $900, right? Do you want that subtracted from the seller's proceed, or do you want the seller to deposit $900 into escrow? What difference does it make?
Maybe taxes.
Actually, the buyer would have slight advantage. If the buyer just negotiate to have the purchase price reduced by 900, right?
We'll be paying less taxes.
Slightly less, not much advantage there, right?
Yeah.
Okay. So I think I will pick, you know, to have the such fund withheld from seller's proceeds, right? All right. Instead of, you know, have the money released to the buyer, too much paperwork, right?
Yeah.
I mean, just negotiate upfront, right? Okay. And we don't have to worry about late charge, do we? If any payment from seller to buyer is required outside of escrow, we don't really expect anything outside of escrow, no. So the late charge probably would not apply though in this case, right? It shouldn't apply though because there's plenty of money in the escrow to withhold the money from the seller, right? So you don't really need any worry about late charge. Now, but as a buyer, even though the seller is not a tenant, you want the seller to maintain the property now. So the seller will be responsible for maintaining the property, and there is a delivery of possession fee. Seller agrees to deposit with escrow holder or such funds shall be withheld from seller's proceeds. A delivery of possession fee in the amount of, why do we need a delivery of possession fee? Most of the time, you know, you don't really need that, right? At close of escrow, this fee shall be released to buyer. Too much work. We don't worry about this. We want everything will be done one time. It's just a deduction from the seller's proceeds, right? Of course, we want to make sure that utilities is being paid by the seller, and that has to be agreed upon, right? Okay. Even though the seller is not a tenant, we want to make the seller make the property available to buyer, to make necessary or agreed repairs like in number 5, to supply necessary or agreed services, or to show property to prospective or actual purchaser. So in other words, even though the seller is not a tenant, we treat him like a tenant. And of course, this is pretty standard. We don't allow the seller to assign or sublet, right? And then we want to make sure that the seller gets his own insurance. Remember, the seller is not a tenant. Can you ask the seller to get some kind of policy to cover for his own personal property? I'm sure you can. You say seller's personal property is not insured by the buyer, and if applicable, not by the owner's association against loss or damage, right? Seller is to carry seller's own insurance to protect seller from such loss. I don't really know what kind of insurance the seller can get because the seller is technically not a renter, okay? So certainly this is in here. And then you put in whatever terms and conditions you want to put in. What are the terms and conditions that you put in on an agreement like this? I think this one has pretty much everything covered. Now, I might put in something like that, okay? Seller agree to hold buyer harmless. Indemnity clause, right?
Yeah.
I want to add an indemnity clause in here, right? Hold buyer harmless against any claims arising, right, out of this agreement. Which seems kind of broad, but if I'm this buyer, I want to put this one in here. Anything can happen while the seller still remains in possession. They could injure themselves. Their guest can come over and injure themselves, right? I'm surprised I don't see language like that in here. I thought that the CAR's attorney would have anticipated this and put something like that in there. If I'm the buyer's agent, I want to let the seller remain in possession. I want to make sure my buyer is protected. I need to add a hold harmless clause, right? Okay. But that's just an idea for you. I definitely put a hold harmless clause in here, right? Okay. All right, next one. Now, what if the seller wants to stay there longer than 30 days? There's actually a separate one there. This is actually a separate form.
Then it will be a lease.
Yes, it will be a residential lease after sale. Let me ask you this. Let's say, for example, if the seller breached the seller license agreement with the buyer. After 29 days, he's still there, he doesn't want to leave. What could the buyer do to get him out of there? Huh? He's not a tenant. He's a licensee, right?
Yeah.
Under 30 days, we don't make him a tenant, right? Now, if he's a licensee, you have to do some kind of eviction. What sort of notice do you have to give him before you evict him? If he's a licensee, do you need to give any notice? Number one, do you need to give notice? He's not a tenant. Why do you need to give him notice? He's not a tenant. No notice is required. If he does not leave on day 29, the next day, I can go to court and file unlawful detainer. No notice is required if he's not a tenant. Got it? Okay. Now the different situation. If he's a tenant, and this one we make him a tenant. We make the seller a tenant, right? Because it is greater than 30 days, right? Okay. And we got buyer, landlord, seller, tenant. That's populated. And it says close of escrow for the purchase agreement is scheduled to occur on this date. You input this date here. Property address is populated. Premises are for the sole use as a personal residence by the following named person only. Usually just put the seller's name here. The term begins on the day after escrow closes on the purchase and sale agreement. This is very similar to the form that we have earlier, the buyer interim occupancy. So you specify the commencement date, which is one day. Actually, it can commence on the same day as the escrow closing date, right? Okay, we make it commence the same date as the escrow closing date. Now, this is now a tenancy. So it says tenant 3A, it says a tenant agrees to pay per month, right? You see this box right here? It says buyer's PT. You know what buyer's PT is? Those that took my loan class. Principal, interest, tax, insurance. So you have a choice because the buyer is going to have PT, right? So the buyers will have principal and interest on his mortgage payment, and he's going to have to pay property taxes and insurance. You can either specify buyer's PT, right? Or you can just pick the amount. Maybe a number higher than buyer's PT. I don't know, whatever you decide you want to do, right? Okay. All right. Okay. Rent is payable in advance on the first day of each month, or putting whatever day you want as the due date for the rent, right? Rent shall be paid. Okay, that's just the manner of payment. 3 and 4 are quite standard, so I won't talk about it. Okay. Standard provision. Escrow payment is not standard. Let's talk about it. Escrow payment, talks about security deposit, first month's rent for the entire lease term. And then you have other per escrow instructions shall be paid out of seller proceeds from the escrow for the purchase of the premises. So you can actually negotiate with the seller ahead of time to have the rent and the security deposit be and first month's rent, security deposit, and rent for the entire lease. However you want to structure this, be paid out of the proceeds of the seller's seller's proceeds from the escrow. Now what should you do? You should just take everything from the seller's proceeds, right? Because you don't want to have any exchange of money after the escrow closes, right? Actually, less paperwork. Actually makes a lot more sense to have the escrow drop out by escrow instructions, right? That's where number 5 comes in. Number 6, you can have a late charge or return check, but we don't have any return check issue if all the money is going to come from the escrow, right? We don't even have that late charge issue too if everything is paid in advance, right? Okay. All right. Parking, storage, utility, same thing. Condition of premises, maintenance and reporting, same. Neighborhood conditions, same. Pets, rules, regulations, condominium plan unit. 15, I'm not sure. Let's talk about it. Premises in the HOA. The name of the HOA is this. Tenant agrees to comply. That's pretty standard. 16 is standard. 17 standard. 18 standard, 19, 20, 21, all the way through to number 27. Tenant's obligations upon vacating premises. This one actually pretty standard, so I'm not going to talk about it. I say standard because it's the same as a standard residential lease for the CR form. Okay. Standard all the way. It is standard all the way. Yes, standard all the way. There are some differences, but basically standard. Now, what happened? Now, this one actually, the term, we don't have a month-to-month tenancy here, do we? We have a term lease. Term lease, when the term expires, the tenant's still there, are we required to give any notice to the tenant before we file unlawful detainer? Wrong. No notice required if it's a term lease. The only time you're required to give notice if it's a month-to-month lease or tenancy at will. This is not a month-to-month lease, and it's not a tenancy at will. It's a term lease. No notice is required. However, if you give notice, if you decide to give a notice, what sort of notice should you give? It's not notice to pay rent or quit. We don't have that situation there, right? If you have to give notice, it is called notice to vacate. And there's nothing wrong with giving notice, but you're not required to under California law. If I were to give notice, I'll give the guy a 5-day notice to vacate. Okay? But again, no notice is required for unlawful detainer based on expiration of a fixed term lease. Just as no notice is required for a situation where the seller was a mere licensee, the time to vacate has expired and is still there. So in either situation, we are not required to give any kind of notice. Although you want to be nice, you want to give notice, then I give him a 5-day notice to vacate. Usually I don't, because usually if the law does not require, Why waste 5 extra days on behalf of my buyer if no notice is required, right? All right.